Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another Roadside Chat from the studio. Okay, so here's our question. It comes from an officer in New Mexico. Basically, the question is if I see a suspect in his backyard, a wanted suspect in his backyard, can I chase him under hot pursuit if he goes into the house? Okay, before I start slicing and dicing this question, let me give you the context of how this question was asked. The officer basically said, I'm reading from my computer here. He was hunting for a person with multiple felony arrest warrants. Okay, that's important. He sees the guy in his grandmother's backyard. He then sees the cop in full uniform and runs into the house. The cop requests backup. Multiple other officers arrive about 10 minutes later. They then do a knock and talk on the front door, and grandma answers. They tell grandma what they're there for, and they seek her cooperation, and they ask her for consent to search for him. She obliges. They then find a locked room. She gets the key. They open it. They find him hiding in a closet. They take him into custody. Supervisor arrives on scene, is not too happy, right? Not too happy because, first of all, he doesn't believe that this was a knock and talk. It's too late at night. Oh, I'm sorry, I didn't tell you the time. It was at 10:30 at night. This is not a knock and talk because of the time. But he said that that if the cop would have chased the suspect by himself, that would have been hot pursuit, but waiting for the other officers to arrive basically nullified the hot pursuit if it was there, right? And so that was one of the problems. Okay, this thing is not a mess. It's just a lot of moving parts. But this is going to be good stuff, okay? I want to walk through it step by step because actually the reality is I think both sides have some good points, but there's some stuff we got to get through. Let's first talk about hot pursuit. Does that count as hot pursuit? The answer is no. Okay. If the guy is in the backyard, which is curtilage, right? The quintessential curtilage is in the backyard, and he sees police officers and he wants nothing to do with the cop, he is absolutely permitted to enter the home, to be left alone. That's just the way it is, okay? It's the way it is. There is no hot pursuit when some guy is just lawfully in the backyard and wants to go into the home. A person has the right to force you to go get judicial pre-approval before entering the home, and so forth. So he's in his backyard, he can go in there. So that's not hot pursuit. Which brings me to the comment that if the officer would have chased him by himself, that would have been hot pursuit, but waiting for backup nullified the hot pursuit. That is not correct. That is not correct. Here's why. If it's hot pursuit, you're allowed to wait for backup to do it safely to get the guy in custody. There is no requirement to, if it is hot pursuit, to literally chase the guy into his house with no backup, unfamiliar territory, where this guy could, go grab a gun and ambush you. You are allowed to be reasonable, which includes waiting for the cavalry to come and then taking him in custody under the hot pursuit. The exigency is still existent. It does not become stale simply because you waited for backup units, right? Now, so I want to handle that issue. It would still be, if it was hot pursuit, it would still be hot pursuit because you waited for some backup units. However, we don't have hot pursuit to begin with, so that argument is out the window anyway. Let's address the knock and talk. I think the officer acknowledges that this was not really a knock and talk. They just more or less relied on the hot pursuit, which you already addressed. Well, let's just talk about it since we're here, right? Could this be a knock and talk? Well, knock and talks are like this. Would the officer believe it was reasonable for the homeowner, right, or occupants to expect or to be welcoming to uninvited guests under the circumstances? Well, the answer is probably not. There are no facts here to lead me to believe that the occupants at this home at 10:30 at night want uninvited guests, police, Girl Scouts, vacuum salesperson, preachers, and politicians, right? There are no facts given to me there. So, and actually, there's probably the opposite. The person saw the police and went into the home. He's actually giving you a signal that he wants nothing to do with you. So, that's just going to help reinforce the fact that this is not a knock and talk at 10:30 at night. So what do we have left? We have left the issue of, well, actually, there's two things we have left. The next issue I want to address is the arrest warrants. The guy had multiple felony arrest warrants for him. Is that going to fix this? Well, it all depends on this. Was this grandmother's house his domicile? Right? If it is his domicile, the cops win because most likely the cops are going to be allowed under state law to execute those arrest warrants at his domicile at night. Now, some states like Nevada and other states, you cannot execute the arrest warrant if it's for a misdemeanor at night, right? But there's no restriction for the felonies. That's a state law thing. You have to check with your state law. But if it's not his residence, then you cannot execute an arrest warrant at a place that is not his domicile. Does that make sense? That is covered under a case called Payton versus New York, and also a case called Stiegel, right? Where the U.S. Supreme Court said you're going to need, if you're going to go arrest somebody in a third party's home, you need another reason to get into the home, not just because they have an arrest warrant. You need a search warrant for them. Some states call these Stiegel warrants and so forth. Okay. The final issue is standing. Does he have a constitutional, okay, even if the cops messed up a little bit here, right? They shouldn't have been knocking on the guy's door. There is no hot pursuit. No, they shouldn't be doing a knock and talk at 10:30. This wasn't hot pursuit. They have no arrest warrant that they can effectuate because it's not his residence. But at the end of the day, does he have standing? Well, under the Fourth Amendment, he does not have standing, most likely, if he's just a guest at grandmother's. Now, if he's an overnight guest, even if temporarily, he may have standing. Well, the other problem, though, the other wrinkle we have here is New Mexico. New Mexico is traditionally a very tough state for cops. And they, in my opinion, they're going to give, even if he doesn't live there, and maybe he's not even a permanent guest, but he probably has unfettered access to the house. It's grandmother. Grandmother probably allows him to come in on his own and so forth. If that's probably likely. They're going to give him likely standing anyway. So that's, now if it's another state, maybe the result is different, but you get my point. So a lot of moving parts in this one, and I hope I'm helping here and not adding more confusion. I don't think I am, right? You let me know in the comments whether this is helping or hurting. But let's go through it, okay? Hot pursuit. Simply being in the guy's back. If a person is lawfully present in his or her own backyard and they go into the house upon seeing police, that's not hot pursuit. People can do that if they want. Number two, knock and talks. Doing a knock and talk at 10:30 at night is going to be a problem unless you can articulate why do you believe the homeowners or occupants would be receptive to having you knock on their door at that time of night. The arrest warrants. Arrest warrants have to be executed at the person's domicile, not simply being at a third party's house, like grandmothers, cousins, friends, and so forth. And then finally, standing. Even if the rules were violated here, does the person have a constitutionally protected privacy interest at the place searched? If it's an overnight guest or the person is given unfettered access by the homeowner, then they usually have standing in all states, especially a place like New Mexico. And that's probably the case here. So at the end of the day, the cops, if they can go back in time, should have actually waited to the next day to do the knock and talk, go from there and so forth, unless they find out that this is his domicile. If they find out in retrospect that this was his domicile, then all the pieces fit nicely together. The Constitution was likely not violated. All right, man, there it is. Guys, I hope you like what I'm doing here, trying to educate cops as best as I can. If you like what I'm doing, I'm going to ask you 3 things. Hit like or comment, hit subscribe, share with your friends. Until next time, my friends, stay safe.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.